Yeah, perfect.
All right. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, January 23rd, 2025. We have 12 bills on the docket, and we're going to start off with Senate Bill 125. Senator Guile, welcome.
Thank you very much, Mr. Chair. It's great to be back in front of JPR for another session. For the record, Senator Don Guile, District 33, here to testify on Senate Bill 125. This bill would close an accidental loophole in legislation we enacted last year to protect residents from eviction. In the 2023 legislative session, the General Assembly passed SB 450 to ensure that Marylanders can summon police or medical services during an emergency. That legislation sought to prohibit local governments from using local nuisance laws to penalize landlords and tenants solely for the act of summoning police or emergency assistance. A handful of local jurisdictions have laws on the books to penalize property owners for repeated calls for police, fire, or EMS service to their property. These nuisance laws subject the landlord or property owner to a fine and possible loss of their rental license if the police are called out to a property more than a certain number of times within a specific time frame. The intent of the 2023 bill was to prohibit local governments from enacting and enforcing such a law. I testified to that end before this committee, as did other witnesses. However, based on the way that the 2023 law was ultimately written, local governments are prohibited only from enacting, but not enforcing, existing nuisance laws. This issue came to light when a county enacted a new local nuisance law shortly before the state law came into effect. This bill seeks to clarify the intent of the General Assembly and the law that we passed in 2023 to ensure that every Marylander has access to emergency services without fear of retaliation by their landlord or their local government. I would note that the 2023 bill passed this committee unanimously. Per the fiscal note, this bill is not anticipated to materially affect state operations or finances, and I therefore respectfully urge a favorable report on SB 125.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Laurie Ruth. I am the Public Policy Director at the Maryland Network Against Domestic Violence. I want to thank Senator Guile for bringing the bill. As she said, it's a very small corrective bill. I will say that yesterday in Judiciary, Delegate Palakovich-Carr, who's a sponsor on the House side, said that she has an Attorney General letter that indicates that the intent in 2023 was to include what we're here to try and fix today. So I hope that this committee, will pass a favorable vote. I just want to make one additional point, which is, the way these laws work, if they are being enforced against people, you're forcing victims and survivors of intimate partner violence to choose sometimes between their own safety and possible homelessness or housing instability, because they can get evicted sometimes, they can face fines that they can't pay, and they end up homeless. And we all know that housing instability is a big problem for survivors of domestic violence. So we really hope that you'll pass a favorable report on Senate Bill 125. Thank you very much.
Thank you, Senator. Thank you very much. Welcome back in person. You look great. I'm glad you're on the mend. Senator West, and then I've got a question.
Thank you, Mr. Chair. That's all I wanted to say. Welcome back. We're glad you're looking so good. After last week, you looked and sounded very poor, so it's nice to see you in good health.
You still don't want to.
You always look great. You always look great.
Just saying.
So hey, I had a question. We had a 4-hour housing briefing earlier this week, and that's the only reason why this is top of mind, was because we were talking about the anti-retaliation statute for tenants and renters. I was wondering, because a part of the statute, which is section 8-208.1, is it says you can't retaliate against the tenant, for instance, solely because the tenant or the individual or another individual, including another resident, summoned the assistance of law enforcement or emergency services to the property. How does that dovetail with this? Because this is drafted to a different section of the code, but I just didn't, are are we talking about the same thing,
Yeah.
or are these are different circumstances?
I mean, they have overlap, I think. I would not knowing certainly as to the retaliation component of it, but this is more so that when certain counties have enacted nuisance laws saying that if there are a certain number of calls, EMS calls, calls for law enforcement to a particular location, that could potentially be, grounds to evict somebody, that somebody could lose their home based on the quantity of calls. And obviously it deters, victims of domestic violence. It deters people with family members, with people living there that have disabilities, that require frequent calls for medical help. And so it has a chilling effect on people that, may want to, forcing them to choose between their home and choosing for care and for intervention by law enforcement. And so that's my understanding. I'm not certain as to the overlap with that, but this would basically say that certain counties cannot enforce and cannot enact such nuisance laws.
Got it.
Yeah.
Yeah. Well, this is definitely laudable. I mean, we're going to work on this. We'll get this together. Obviously, I'd wonder, this is preemption. I mean, the state law preempts local ordinance. So I wonder if it's just not being enforced properly or what, but we'll get to the bottom of it.
Okay.
Senator James has a question.
Just a clarification. Thank you for bringing this to us. So it's your understanding that the crux of the problem is some counties are looking just at the number as opposed to, because I don't want to tie people's hands in the event that you have someone for a variety of reasons that's calling a lot. I mean, you're thinking about doxing, but it's not that, but are just calling a lot and a lot for reasons that aren't legitimate, aren't domestic abuse. Maybe they need mental health treatment, I don't know, but they're calling a lot. So how does it work where law enforcement or counties, whatever, are finding that there might be an incident where an individual is doing this for other reasons? Maybe they vicariously get a thrill out of it, or they're just kind of misusing it. So there are those cases, I'm sure they're rare. How do we just allow them to distinguish that from this? Is it just by not allowing them just to look at the number of calls, but look at the context, why the call happened, what the circumstances are? Is that your understanding?
It's saying that the quantity of calls cannot be the basis for an eviction.
Just the quantity, as
Right.
opposed to the so they could still look at the context, what's going on, if all these calls were bogus or odd or just not the right call to make, and the person is just not comprehending this isn't the way to use local resources. Is that your understanding?
Yeah, I mean, I'm sure if there's somebody that's, making frivolous calls for a service, I mean, I'm sure that there's probably an avenue that police can make. I don't know, but I assume that there's probably an avenue that they could take. But this is saying that that can, and it really is a policy matter. We don't want to have people feel like they can't call.
I get that.
So I think that's, otherwise they risk losing their home. So I think that this is the main issue to your point, is that it cannot be grounds for an eviction.
And I'm sort of bringing it, there's this thing with doxing and people really making terrible calls on other people. So I just want to make sure we're not tying hands for discretion of context, versus just sheer number and not looking at anything else, which I understand is the intent of your bill.
Right.
All right,
Yep.
thank you.
Seeing no further questions, thank you very much. Thank you, Senator.
Yep, thank you, Mr. Chair.
Actually, did Bill Costelli come up yet? I know who's signed up. Come on up. Welcome.
Thank you, Mr. Chair, and members of the committee. Bill Castelli on behalf of the Realtors, and we are in support of the bill for all the reasons you just heard. This does impact tenants, landlords, and one of the issues that you raised, Chair Smith, because landlords can get fined under these statutes, that part of the code is, clarified on the retaliatory eviction that they would not be able to take action against the tenant for it. And this would certainly remove one of the reasons why a landlord would want to take action if they were getting fined, $500 for a tenant who called numerous times. So.
Excellent. Well, thank you. Questions for Mr. Costelli? Senator West.
Thank you, Mr. Chair. So I'm looking at the statute, real property statute, section 8-208.1, which is retaliatory actions. And that appears to say tenants landlords can't take retaliatory actions in this kind of a situation. But this bill, Senate 125, which is written to section 14106, it refers to governing bodies of a county who can't take action. So it sounds like we're talking about the same thing, but the one deals with landlords and the other deals with governing bodies of the county. Would you agree with that?
Yes.
Okay, thank you.
All right. Seeing no further questions, thank you very much, Senator. That'll conclude the hearing for Senate Bill 125. We'll now move on to Senate Bill 32. Senator Guile.
Thank you very much, Mr. Chair. Senate Bill 32, this is a bill that last year passed the House unanimously and did not get over to pass through the Senate in time before sine die. So, and it now has obviously a sponsor in the Senate. So what Senate Bill 32 reinforces Maryland's commitment to supporting its active duty service members and their families. The problem stems from the unique challenges faced by service members who are Maryland homeowners who rent out their Maryland home and return to the state on orders. As members of the community may know, under current law, when a landlord gives a tenant proper written notice to leave the property and the tenant does not leave, the landlord may file a written complaint with the district court of the county where the property is located. The court then issues a summons telling the tenant to appear in court on the stated day. The constable or sheriff will serve the summons on the tenant. If no one on the property can be found, the sheriff or constable will post a copy of the summons on the property. If the tenant has also been sent a notice by first-class mail, the posting of the summons will meet the service requirement. When both of the parties appear in court for the eviction proceeding, the tenant will have the opportunity to explain why he or she should be permitted to remain in the property. If either the landlord or the tenant fails to appear at the eviction hearing, the judge may decide to postpone the hearing for not less than 6 more than 10 days after the date of the summons. If the court rules for the landlord, then the court will immediately issue a warrant of restitution. The warrant will be served by a sheriff and requires the tenant to leave the property, returning the property to the possession of the landlord. However, due to overall backlogs in our system, the process just outlined can take several months, leaving service members who are returning back to their home on orders in limbo with no ability to reoccupy their primary residence. This exact scenario happened to Anne Arundel County resident Michael Ash, who is here with me today, in late 2021 upon his return to the state on official orders. Because of a tenant who refused to vacate and an overburdened system, this service member's family couch surfed for 4 months. This bill does the following to limit these kinds of cases in the future. It requires the district court to hold an eviction proceeding within 45 days of the landlord filing their complaint. It allows the summons to be served by a private process server if the sheriff or constable does not serve the summons within 10 days after issuance. This process is only allowed if the landlord or the landlord's spouse is on active duty with the U.S. military, has relocated to the state as a result of being on active duty, and intends to occupy the property that is the subject of the complaint following the entry of a judgment and submits supporting documentation. This bill recognizes the unique challenges that active duty service members and their families face when returning to the state while maintaining an orderly procedure that protects tenants and their families. As I noted, this bill did pass in the last year in the House unanimously. There is no opposition to the bill. It's not anticipated to materially affect state operations or finances, and I therefore respectfully urge a favorable report on Senate Bill 32. Thank you.
Good afternoon, Chair Smith, distinguished members. For the record, this testimony does not reflect the views or opinions of the United States Navy or the Department of Defense. In 2019, my wife and I rented our Maryland home of 5 years while away on orders. In 2021, we got orders back to Maryland starting February 2022. Our tenant's second lease expired October 31st of 2024. Our property manager notified the tenant that we would not be renewing. Thinking she'd honor her contract, my wife and daughter drove from Washington back to Maryland in November. I was at sea at the time. The tenant did not vacate. She requested a series of short extensions until receiving notice that the holdover hearing wasn't until January 18th of the following year. She then made it clear that she'd stay until then. We filed a motion to expedite the trial November 17th, but that request was denied without explanation on December 3rd. The tenant did not show up to court and abandoned the property the day of. Luckily, we didn't have to go through the eviction process, which could have added months to the process. 4 months passed from the time the lease ended to the time we were able to move back in. We were extremely fortunate to have a friend in the area willing to put us up for that time. If we hadn't, we would have likely been paying for a hotel or month-to-month rental without access to our personal property because of our PCS. I can't put into words the frustration, helplessness, anger, and abandonment we felt waiting for that trial. The government, to which my wife and I have spent our entire professional lives in service to, would not or could not do anything to help us. Meanwhile, the county health department was threatening to fine us for trash accumulation on the property that we weren't allowed to enter. My daughter spent her 4th birthday, Thanksgiving, Christmas, and New Year's sleeping on a beanbag chair. So much of our time that should have been spent focused on our jobs and family were wasted talking to lawyers, our property managers, and making pleas to the Maryland judicial and legislative branches. The law needs to provide protection to renters and landlords alike. No one should have to wait 2.5 months to have a tenant holdover case heard when it's preventing them from moving back into their home. Thank you for your time. I request a favorable report for SB 32.
Thank you very much, Senator. Thank you for your testimony and your service. Is your Navy?
Yes, sir.
What's your MOS?
I'm at 1820
Awesome.
IP.
Yeah, excellent. Go Navy.
Go Navy, sir.
And we beat Army. So there you go. Sorry, Senator Guile. Sorry, you know. All right. All right. So Senator Sidnor, and then we'll go to Senator Henson.
Good afternoon. I just want to make certain, just to clarify, this is for tenants holding over. So the lease that the renter and our service person landlord would have expired, correct?
Exactly.
Okay.
Yes.
Thank you.
Thank you, Mr. Chair, and thank you, Senator, for bringing the bill. My question is for your witness. Thank you.
Ma'am?
I'm trying to understand the resources available to a person who's being relocated by the military, and then I'm trying to, in my mind, compare them to the resources available to a tenant whose lease is not renewed, and now they're in a position of having to find a new place to live. Could you help me understand what resources are available, if it's your specific situation or just speaking generally, when someone is relocated by the military? What sort of support does that come with, if any?
So the military does pay for all moving costs. Typically, there's a 2-week grace period when you get to the other side. I believe it's 2 weeks, don't quote me on that, where you can be in a hotel and the military will pay that as part of your travel costs. We did not go down this road. There is military housing available, though I don't know if we would have qualified for it since we had a house in the area. And even if we did, we wouldn't have been able to have our personal property delivered. So we'd have basically an empty house to live in, assuming that the military had the available houses to put us up in. There are some rental furniture services that the military provides. I don't know if that's available in CONUS. I know that's available at OCONUS because they're used to people's household goods taking a long time to arrive. Compared to somebody whose lease expires and they're not, they need to find a new place to live. My understanding and what I remember is they have to be notified 90 days in advance, which I would think would be enough time to find a new place.
Okay. Thank you for your testimony. Thank you, Mr. Chair.
Further questions from the committee? All right, seeing none, thank you both very much. Thank you.
Thank you.
We have a couple more witnesses signed up in favor. Is Shannon Ledbetter here? David Ludsow? And then Mr. Hill, you're signed up favorable with amendments?
Good morning. Actually, I think it's afternoon by now. I'm the newest member of the Maryland Military Coalition. So you guys drew the short straw because this is the first time we'll be testifying before a committee. But with the Maryland Military Coalition, I find myself being the most qualified to address this particular situation. 27 years Air Force, although my dad was Navy. 27 years Air Force. My last 10 years as a first sergeant. So we deal with a lot of these issues, and I can talk personally to an experience that took up to 5 months to get a family back into their home. And now, make no mistake, this is a quality of life and emissions issue, because as members, when they go through that stuff, the stress the family goes through, it goes to mission readiness, because if you're not focused on your job, you're more focused on your quality of life issues, then that becomes a problem for the organization and the following members within that organization. So I just want to make sure that we understand that this is a quality of life and a mission readiness issue with this bill that would fix. Now, one could argue the moralities of one tenant or another in housing or not housing, but that's what this bill would do. It would expedite the process to get these into the court system and allow the courts to do the job that they're required to do. It's not up to myself or commanders to have the, do the morality check on this. That's what the court system is there for, and I appreciate the senator for bringing this bill before this committee so this can be resolved to help military members with these particular situations. So, thank you very much. Yes. Yes, we are favorable with the amendments. I'm sorry. Favorable with the amendments, sir. Yep.
Yes.
Correct, yes, yes.
We'll do questions for the favorable, then we'll switch over to the favorable with amendments. I saw Senator James first, then Senator Charles.
Thank you, Mr. Chairman. I know this is the bill that passed, and I'm trying to understand if there's even a better way. It's sort of not to confuse things, but, and I don't even know if this is allowed, but to me, there could be a way in which these kinds of leases, so you can engage with the tenant, and as long as the military personnel notifies clearly you're engaging in a tenancy with a military personnel, and upon their return, there has to be immediate access to the property, and let's say you continue to have the 60 or 90-day notice, and otherwise there's a summary eviction and you can bypass the court. And the only reason I say that, I happen to be no longer in my own home and renting from a military, I can't imagine holding them up like that, particularly under the circumstances of their service. But I really do know I'm contracting with a military person and what that's like, and maybe that's not possible. I don't know if anybody looked at it, or maybe just the equities of dealing with tenancies. You don't want to come up with some sort of summary procedure. But if we pass this, rather than 4 or 5 months, how much have we shortened the process for everybody involved so the person can regain possession of their home? Can you just?
Well, that would be situational dependent. And
sorry, I know a year tenancy, it might be like 60 or 90 days you give notice. Let's just assume it's more than a week, because I'm assuming most of these tenancies are a little longer than a week, like a yearly. How much shorter will the process be under this bill?
Actually, I think that there was testimony that was provided in the favorable with amendments to written testimony that most of the time these hearings are indeed held within 45 days. But there are circumstances where, depending on the backlog of a particular courts, know how some circuit courts maybe, certainly after COVID when circuit courts were trying to catch up. So I think it just really depends on the docket and how quickly. But I think most of the time these are handled just generally in a fairly expedited manner.
Good.
The hearings are indeed set usually within 30, 45 days.
Because most of these contracts, whether by law or maybe statute, if you're in a year tenancy, you usually get 60 or 90 days, which is good because then the personnel, the military knows, I guess, to some extent, if the tenant's going to leave, and you're still within some period of time, and then you can go to court. But do you have to wait till the very end of the tenancy, or if you understand the tenant is not cooperating, can you go then, or do you have to wait till the tenancy and then you can get a hearing, hopefully expedited, but in 45 days? How's that work?
Yeah, this doesn't change anything within the lease agreement. I know, for example, the Service Member Civil Relief Act allows for tenants that are service members to exit a lease early. This does not mean that a landlord who's a service member can somehow end the lease with their tenant earlier. They
Not
still have
early,
to.
not early.
Yeah, they
No,
just,
I'm
they
not-
still have to follow the law as far as what the notification requirements are, how the lease agreement is set up for its termination.
Right,
This
right.
just is saying that if there's a holdover tenant, that they should get an expedited, they need to get the hearing date set within 45 days so they can get back in their home.
Thank
If it's,
you.
yeah, occupied by
All right,
them.
thank
Yeah.
you.
Senator Charles.
Thank you, Mr. Chair. I just couldn't allow you to call out the Navy without acknowledging my Air Force comrade over here and say, go Air Force.
There you go. And Senator, to go back to the question that you had about the leases, this bill is only one aspect to help with this process. And I can't speak to all commands, but I know when any of my members were leaving or departing, one of the things we did was we worked with the management companies because they write the leases.
Right.
So the language in the lease is another aspect of this that the military commands need to start working with their members on
Yeah.
to ensure that language is enabled to prevent these particular type situations. But just so you know.
think
on
that's a
the-
good idea,
Right,
a
on the
really good
military
idea.
side, we have been and are looking at that when the members leave to make sure the management companies are doing the members fairly so that way they're not being taken advantage of before they come back. So yes, on the military side, Command, we are
Good.
taking care of those things.
Good, thank you.
All right, seeing no further questions from the committee, thank you very much. We'll now move over to the favorable with
Thank you,
amendments
Mr.
with Mr. Hill.
Thank you, Mr. Chair, Mr. Vice Chair. Again, Matt Hill, attorney at Public Justice Center, and we are favorable with amendments. I certainly appreciate the testimony that was shared here today. And as Senator Giles said, our experience is that most of these cases are heard within 45 days of filing. So we don't oppose that provision. My guess, I wonder if the pandemic disruptions that everyone experienced at generally the time that this was happening may have contributed to some of the situations that the committee's hearing about. That's my guess. I don't know. What we are concerned about is the provision that allows a private process server to do process in these cases. These cases are generally nail and mail, so first-class mail and posting on the property. There's no personal service. And the sheriff, for all eviction cases, is tasked with completing that process. There's a system. They're an independent, neutral, third party. So we are concerned about opening the door to allowing private process servers into this system because they are paid for by the landlord and may not be the third-party independence that we have in the sheriff. I didn't hear any testimony with respect to the sheriff not serving within 10 days. Our experience is the sheriffs generally do serve timely, and so we're just concerned that the committee would be taking the sheriff out of this process. It could lead to taking the sheriff out of other aspects of the eviction process for non-service members as well. So we urge the committee not to go down that slippery slope without additional data with respect to the sheriff's performance. Thank you.
Thank you, Mr. Chairman. Thank you, Mr. Hill, for your testimony. In my experience, the courts can be pretty stubborn, and sometimes will pass a law, like when the law said summary ejectments must happen, the hearing must be scheduled within 4 days of the filing date, and that rarely happened. If we put into legislation the 45-day window, based on your experience, if it was a court that was experiencing backlogs or for whatever reason, do you think that a court that's not able to meet those challenges on a regular basis, if we legislated that what effect do you think that would have on the ultimate outcome?
I mean, so many of the problems this committee faces, I think we face, are, how agencies function within the laws that are provided. So will definitely then all cases be heard within 45 days? I don't know. Will you have a hook in the law to then go to the judiciary and say, hey, the legislature says 45 days, this needs to be within 45 days, and engage in that more political process with the agency or the judiciary, then yes, I think it's useful in that respect. If we have another, God forbid, bird flu pandemic, I mean, all bets are off in terms of when something's going to be held to protect public health and safety.
you raised an interesting point on implementation. Do you think if we included language that said, I don't know, the judiciary has to adopt by regulation identifying this on the form, where they have to provide a checkbox if you are filing this and you are a landlord that meets the requirements of being military, military spouse, all the different qualifiers, so that a clerk's office could readily identify? Or do you think we need some sort of enforcement mechanism with the bill where you have the right to request an expedited hearing when you file at the same time? Like, what's the best
Right.
way forward practically?
My sense is, based on prior experience, if the committee passed this bill, the court would likely, through its forms committee, adjust the form and add that kind of very checkbox where someone could request, hey, I qualify under this particular bill for service members. I'd like an expedited hearing. That's generally how it works, I think.
Okay, thank you for your expertise. Thank you, Mr. Chair.
No, I assume that's why we didn't hear from Chief Judge Morsi, because these things already happen within a 45-day period of time anyway, but generally they usually weigh in on this stuff.
Yes, Mr. Chair, that's our experience. And again, I wonder how much of this is related to the pandemic insanity.
And the Rules Committee could almost handle this entire thing. I don't know.
I don't know if the Rules Committee sets specific dates out from when a complaint's filed. I'm not familiar with that being part of, that could be, I don't know.
All right. Best to have it in statute, though. That's good. So, all right. And further questions from the committee? All right. Thank you very much.
Thank you, Mr.
Hill. We do have one witness signed up to testify virtually, but I don't believe they are in the room. So that will conclude the hearing for Senate Bill 32. Thank you very much, Senator Guile. All right. We will next go on to Senate Bill 189 with Senator Brooks. Is Senator Brooks here? Yep. Hey, there you are. Welcome.
Thank you. Thank you, Chair. Chair Smith, Vice Chair Walt Stryker, and members of this awesome committee, thank you for the opportunity to testify before you today on Senate Bill 189, the eminent domain, agricultural and conservation easement prohibited taking. The purpose of this bill is to keep our state's promise to property owners in light of the proposed Maryland Piedmont Reliability Project. It's called the MPRP, by prohibiting the state or its local government from using eminent domain to take privately owned property that is subject to perpetual agricultural or conservation easements. The MPRP is a new transmission project awarded to the public service, awarded by PJM to a group called a Public Service Enterprise Group, PSEG. It was awarded by PJM, which stands for Pennsylvania, New Jersey, and Maryland. That's our interconnector. And they provide power to 13 states as well as the District of Columbia, you know. And their purpose is to operate and plan to make sure that the grid is stable and we're getting the amount of electrons that we need. I guess if I could use an example of the RTO, the PJM, you could look at their service. Like, let's look at a tub, a bathtub, and then you've got generators who are putting water in this tub, and they would take that particular energy, and they would give it to the various 13 states or the District of Columbia as needed. You know, so that's to make sure that there is reliability, that when we need those electrons, that they are always there and available. Yeah. The goal here, and their goal is to improve and enhance and supplement the grid to make sure that that power is available and ready when we need it. Now, this MPRP, they're talking about 70 miles of 500 kilovolt high voltage line coming from Pennsylvania all the way down to Frederick County. It's going to impact Baltimore County, Carroll County, and of course, Frederick County. And they are going to be coming across private property. Yeah. And the main concern by these farmers and the landowners is the fact that that property is going to be seized through eminent domain. Now, we don't have this concern with BGE. BGE's got property rights coming through. And they and you don't have the firestorm or the major concern that we have with PSEG because they don't have any rights to come through. Yeah. Right now, Maryland, we are net importers. You know, we generate what 60% of the electrons that we use in the state. 40% is being imported. We are shutting down generation. Brandon Shores, that was like 1,300 megawatts of power, but we didn't supplant or replace it with anything. So with that, Brandon Shore, PJM issued an REMI reliability must run to run Brandon Shores to generate the additional electrons that we need. And with that came a tremendous increase in price that I think that we will all start seeing in June 1. Yeah. So, but here again, the purpose of this bill is to protect land preservation, and then conservation easement. Yeah. If we were to continue to do that, we can further the passage of Maryland trying to obtain an open space, keep it open space. And right now, we are about, say, 5 years ahead of time. We wanted to, by 2030, we wanted to preserve 30% of the land in Maryland. We're 5 years ahead of that conservation easement. And by 2040, the goal is to preserve 40%. Yeah. Seizing these lands through the construction of transmission line will decrease productivity for farmland and agricultural economic growth from our state. Moreover, the construction of and ongoing maintenance of the high voltage transmission line will be destructive to the natural habitats and the ecosystem. Furthermore, allowing the acquisition of land would lay the foundation for future seizure of property by means of eminent domain. These lands should not be a viable option for transmission lines because the landowners have stewarded them with a promise that they would be conserved in perpetuality. By allowing construction of these high voltage transmission line on these locations, our state will be breaking a promise to those farmers and landowners in less than one generation. While PJM may claim that the Maryland Piedmont Reliability Project is necessary for grid reliability, it comes at a dire cost to Marylanders. Our state cannot and should not break its promise to these residents who have invested time, money, and care in conserving our pristine agricultural land. Eminent domain should not be an option when it comes to landowners' assurance and environmental conservation. And for that reason, I ask for a favorable report, and I might add as well, we did get an amendment from MACO and who is also supportive of this. And I do have some panelists, Mr. Chair.
Yes. Would you like me to call them up? And
yes, please.
Okay, I'll just do that. So Joanne Frederick, Michael Sonnefeld. Michael, I've got questions for you about the conservation process when you finish your testimony. And then Tyler Huff. Maybe Tyler can answer those questions too. Susan Gordon. Okay, we'll start off. Welcome.
Okay, thank you. Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I'd like to acknowledge Senator West as well, who's been working with us on this issue, and many thanks to Senator Brooks and Senator Heddleman for introducing this legislation. My name is Joanne Frederick. I'm president of Stop NPRP, Inc. We created this nonprofit in July of this year upon hearing the threat of the MPRP, as Senator Brooks described. We have representatives from each of the 3 counties and the organizations as board members. We have about 1,100 members as of last week. A few stats on the MPRP. So it's about over 1,100 acres of destruction. Of that, 245.8 is reported in the application to be conserved, though we do know there's some underreporting. There are additional parcels that are in conserved status that weren't identified in that application. Additionally, 1,801.7 acres within 500 feet of the right-of-way are also in conserved status. So we can imagine this power line comes through and destroys everything 150 feet wide. That's catastrophic enough, but then there's an additional 1,801.7 acres within 500 feet. Hard to quantify the impact to that. Maryland has 1.85 acres in preservation, and there are 3 reasons why this bill is so important. 1, to protect the investment. The mouth easements alone, $907 million invested by Maryland. The rural legacy easements, an additional $405 million as of 2024. As Senator Brooks talked about, its commitments. I happen to own a piece of property. My property is covered by 2 forest buffer easements and 1 land preservation easement. I can't disrupt existing vegetation. I cannot disrupt the soil. I cannot apply pesticides. I cannot house animals in this land. And the power line comes through and takes 5 acres of this. So Maryland made a commitment to all these easement holders. And is it a breach of contract, or would Maryland then be subject to additional legal action? And then lastly, what landowner will preserve land in the future if this is allowed to happen? Thank you.
Thank you, Committee Chair Smith. I'm Michael Sonnenfeld. I'm in the Easement Committee of Land Preservation Trust, and we're here to support Senator Brooks' bill, and we're here in favor of it. Land Preservation Trust is a local land trust that holds over 380 conservation easements on over 14,000 acres of land and is the administrator for the state of Maryland of the Piney Run Rural Legacy Area. For over 40 years, Maryland has invested over $1.3 billion to protect agricultural and open space land throughout the state by purchasing conservation easements on properties and creating the legal structures to support donations of conservation easements. Conservation easements achieve critical state goals at a significantly lower cost than the outright purchase of land. The landowners remain responsible for the maintenance of the property, and the conservation easements allow the state to dedicate land to an important public purpose at a low acquisition cost with no ongoing expense as the owner of the land. Conserved land maintains water quality, air quality, captures carbon, and limits greenhouse gases. So these are, and they also maintain the scenic views and rural character of the communities in which they're located. So Maryland's Rural Legacy Program, the deeds of easement specifically designate the protected uses of the conserved properties to be their highest public uses. Landowners take the decision to conserve their land very carefully, understanding it's a permanent commitment to maintain the property in its natural state. SB 189 will assure that the state will also protect conserved lands in perpetuity. So finally, protecting conserved lands is critical to Maryland's success to achieve its goal of protecting another 600,000 acres by 2040. So again, we request a favorable report in Senate Bill 189. Thank you.
Mr. Chairman, members of the committee, for the record, my name is Tyler Huff. I am the Director of Government Relations for Maryland Farm Bureau. There's nothing I can say that you haven't heard from the panelists and the Senator already, and we thank the Senator for all his work and Senator West on his work as well. I will just say the Maryland land preservation programs are renowned around the country about their quality, their ability to get the work done, and their ability to conserve land. I believe we have some of the highest totals of preserved land in the entire country. This legislation is not only about protecting land, but it's about honoring commitments made to Maryland farmers and landowners who have entered into this preservation agreements. It also serves to uphold the state's broader goals of fostering sustainable agriculture and conserving natural habitats. You did hear that the senator mentioned MACO has submitted amendments. Maryland Farm Bureau is comfortable and supports those amendments as well. And we thank you, your committee, for the time, and Maryland Farm Bureau urges a favorable report. Thank you.
Thank you, Senator, for bringing this bill. Just by way of background, my farm is the first one to be put into the Maryland Environmental Trust, which was came before Program of Estates, which my father created. So I'm very familiar with, you know, the importance and the foresight of Maryland and its national prominence in this. I have a lot of questions that I'll follow up with the sponsor, but just reading the fiscal note, I have a sort of technical question. I noticed that MALF, which came later than MET and Program Open Space, they apparently, according to the fiscal note, have expressed language about MALF's ability to go ahead with the property owner and grant, you know, easements or condemnation even for things such as bridges, roads, and utilities. Then the fiscal note goes on, and I just didn't grab the statutes because there's quite a few of them. They talk about the other programs I just mentioned, other easements, because we have a variety. The fiscal note doesn't mention whether or not those other easements and protections had an express carve out for the owner of the easement, which would be some state or local entity, you know, promoting from the delegation of the state to protect it, whether they have express exceptions to utilities and bridges. So that would be my first one. And then secondly, sort of, is it your position for the bill that even if that was contemplated in either statute or the individual contracts or case law, that we should then take the position that we will then discontinue that option for any amendment to a conservation easement for utility purposes? So is there some exception expressly? MALF is mentioned, the others are not. I don't know if that's significant. And then is the position that this bill will say, guess what? We're going to eradicate any and all of this, whether it's statutorily in the contract or otherwise.
Okay, let me see if I understand your question.
I know it's long.
Okay.
I can break it down.
Yeah, this bill is sort of narrowly focused, you know, and it has to do with just a perpetual easement. We don't want that to be.
These are all perpetual easements that I just referenced.
Perpetual agriculture and then conservation easements.
Right.
Yeah, so so just sort of narrowly focused to.
Yeah, that was what my question was about,
Right.
both of those.
Okay. Okay. You want to say something? Yeah.
You followed, Officer. I'm talking about all the perpetual conservation easements. I just noted that the fiscal note talks about MALF having already statutorily exceptions for bridges, roads, and utilities. I just noticed that the rest of the fiscal note doesn't do that. That does not mean that is not in statute. I didn't know if you could speak to that. And then I guess what I'm saying, the bill is suggesting whether it's expressed like in MALF or otherwise silent in the others, but maybe by contract, depending on the landowner, this bill would eliminate that. Is that in its totality across all of these types of perpetual easements?
Yeah, the MALF statute, enabling statute, specifically says that a MALF easement does not prohibit things like transmission lines. So this bill, I think, would be interpreted to override that.
Okay, that's what I wanted.
Would be my reading.
Thank you.
And then the other easements the newer easements are much more detailed and prohibit specifically commercial activities, including utilities other than for serving the property itself. But some of the older easements are silent. I mean,
you're right. I think mine were pretty old. And so it was pretty silent, and they morphed over the years. And then they tried to kind of stay current because people learned, oh, you know what's good? We can do this with our farm that was restricted before, but keep a farm viable, let's say. They
Right.
start doing and things like that. So you're right about that. So I think with the other easements, it depends on what it says. But I guess what I'm reading the bill, maybe I'm wrong, this would just across the board, doesn't matter which easement it is, mouth, POS, or any other one, we just will eliminate that option for eminent domain for utilities. Is that
Right.
correct?
I think that's right. I think
Okay.
but the easement terms may or may not prohibit things like the power lines.
Right.
And I think what the bill does is to essentially protect the investment that the state has made in conservation, so that things like power lines don't.
I guess what I'm
override them.
trying to figure out is, I get the statute part, but if you were a private property owner and you entered into an easement in 1998, and you negotiated with the entity and said, I do want to carve out the ability for utilities, maybe they'll pay me, I don't know, you have that flexibility. We would go in and enter and override these private contracts
No.
with this bill?
I don't
No, we
think so.
wouldn't.
The bill is limited to the use of eminent domain. If the landowner has the ability to enter a contract with the utility, that's not affected by the use, by a limitation on the use of eminent domain, as I would read it.
So it would only be if it was an adverse an adverse action, the property owner, the easement, the property owner, not the easement, doesn't want this to happen, regardless of what else the law may say or the contracts may say. We will be with them and say, if you don't want this, no mechanism for eminent domain can override your wishes. Is that the scope of the bill?
I think that's,
Is that?
if I follow your question, yeah, I think
I'm
so.
not trying to complicate it, I'm just
Yeah.
trying to make sure I understand it.
No, if the easement would allow it, then this bill doesn't affect it.
I got you, right.
But if the easement prohibits it, which a lot of them do,
Right.
this bill would prevent eminent domain from overriding the easement.
Got it. All right, thank you, Mr. Chair. Yeah.
I'd say this, I think the amendment that we got from Mako,
Do I have that? I'm sorry. Is that in the file?
well, actually, Kim, was that?
It's okay. You can talk to it.
Okay.
If I don't have it,
Yeah,
that's okay.
it's in the testimony, yeah.
Okay.
I think it would address that concern you have, and it says, the critical infrastructure includes the physical structure of facilities needed for the operation and delivery of public service. Critical infrastructure does not include the physical structure or facilities used for energy generation or transmission.
Okay, I'll read that. Thank you for bringing that to my attention. I'll
Okay,
find that. Thank you,
yes.
Mr. Chair.
Quickly, Senator Brooks, you just alluded to the Mako proposed amendment. Do I understand you to say you accept that amendment and would like it to be added to the bill?
Yes, we will.
Okay.
We do.
And secondly, Ms. Frederick, can we talk for just a moment? One of the aspects of this that I don't think has been brought out is the following. Would you agree with me that when land is put into a conservation or preservation easement, essentially it loses all of its developable value?
Yes, sir.
Because land in such an easement can't be developed for an office building or an apartment house or a residential structure or even a barn or other outbuilding for a farm.
Correct.
It loses all of its developable value at all.
There are restrictions, and the easement agreements are different. So there are many, many different types across the counties and states. They're very different. So I wouldn't say it loses all of its value, but I think it loses its developable value, if that's a word.
Okay.
So I can't, take me for example, I can't sell a portion of my property and put a housing unit on it, et cetera, because of the restrictions afforded by the easement. And it's that commitment that I was absolutely willing to accept.
And would you also agree with me that that being the case, if the land were to be appraised for its fair market value, the appraisal would necessarily come in at a lower amount than if the land had not been impressed with the preservation or conservation easement?
Yes, sir.
And therefore, would it not be in the interest of a transmission company to try to seek out conservation or preservation land to acquire via eminent domain in order to reduce the cost of the transmission project?
Yes, sir. We absolutely believe that.
So rather perversely, in Maryland, if this PSEG company is permitted to acquire land by eminent domain, it would be in the interests of that company to try to target preservation land and conservation land for acquisition, because it would reduce the cost of that. If that company has a fixed price contract, which it does, to build the transmission line, it would reduce the cost of building the line and thereby increase the profits to the company because it would be paying less for the land.
Exactly.
Thank you.
Essentially put a target on our preserved lands back.
Thanks very much.
You're welcome.
Thank you very much. I had a question for the sponsor.
Yes.
Have you had an opportunity to look at the Department of Transportation's letter?
I did.
There's a footnote number 1, and it says, while the bill does not prevent acquisition of land subject to the identified easements, it does prohibit the use of eminent domain for this purpose. As a result, the department may need to pay an amount far in excess of just compensation for land necessary to complete important public infrastructure projects. Where this land must be obtained to complete these projects costs increase and projects may be abandoned if no alternative exists. Do you have had you considered this particular comment?
Yes, I have. You know, there is a possibility that it would increase. There's a possibility also that they could reroute or go around, you know. So just I think land still can be acquired if the landowners decide to sell. Yeah. So yeah, we did. I think also there is a possibility that that they would still be able to obtain that property if need be. Yeah.
Senator West.
Mr. Chair, and sorry for a second bite at the apple here, but this responds to Senator Sidner's concern. I'm looking at the amendment that you've agreed to add to your bill that MACO has proposed, which exempts from the coverage of your bill critical infrastructure. Critical infrastructure does not include structure for energy generation or transmission, but it would include, would it not, roads, highways that MDOT would construct.
Exactly. That's exactly what I was referring to. Yes.
Exactly. So, so if MDOT needs to go through preserved land in order to build a highway, it would be permitted to do it under your bill.
It would. Yes.
Thank you.
Thank you.
So apart from the perverse incentive that was elucidated by Senator West's fine line of questioning, is there any, what can be done to prevent, to curtail that practice or to prevent it? The practice of going after conserved land at a reduced price. That's one thing. And we can get back to in writing on that. But then second is what, for the statute, so for perpetual, is it perpetual agricultural or conservation?
Conservation easements,
yeah, okay.
Yes.
Are all of those under the Maryland Agricultural Land Preservation Fund, or those, so that's not all of those fall under those exceptions that are provided in that portion of the statute? Okay.
Yeah. Yes, Chair. One thing you could do to prevent that is to pass the bill. So.
No, the reason why I asked that question, because it's, I mean, we're going to have, I'm like sympathetic to this problem. I mean,
right.
Time, but it is a slightly larger bill than I think, you know, than I may even actually realize at this moment. So we'll have to kind of continue this conversation. But
okay,
that's the reason why I asked the question. And
all right.
Senator James kind of got me thinking about that. Yeah.
Okay.
Further questions from the committee? Excellent. Thank you very much.
Thanks, Chair.
Chris, you win the award for best line of questioning so far this session. That was good. That was really good. All right. All right. So we heard from, is Susan Gordon here? Susan Gordon? Lindsay Thompson? Brandon Hill? Excellent. welcome. Welcome back.
Thank you. Good afternoon, Mr. Chair, members of the committee. My name is Lindsay Thompson, here today delivering favorable testimony on behalf of the Maryland Grain Producers Association. So while this bill specifically was precipitated by the Piedmont Reliability Project that's impacting several of the counties in central and western Maryland, we do see this as good practice for projects moving forward as well. I'd like to speak specifically to the Maryland Agricultural Land Preservation Foundation program, which was founded in 1977 by this legislative body. And I'd like to read you a couple of the statutory purposes for that program. And it was to preserve productive farmland and woodland for continued food production, and also for the preservation of those properties for open space. Taking of these preserved agricultural lands for the purposes of overhead transmission line is directly counter to the purpose of those land preservation easements to begin with. Additionally, I'd like to key in on the challenges that these easements provide or have on farmers trying to continue to farm these properties. So one of our members actually is impacted by this project specifically, and the proposed route bisects two of his farms, one of which is pretty much directly in half. And with the easement agreement, he would not be able to essentially farm both of those parcels. It would make it exceptionally difficult for him to get from one parcel to the other, because the easement agreement says that he cannot move equipment greater than 12 feet tall under the lines through that easement. So he would have to essentially go on a major road with that equipment several miles around the lines in order to get to the other part of his farm. And so we feel as though this would be protective of the purpose and the investment of the state in the land preservation programs. Thank you.
Questions from the committee? All right, excellent. Thank you. Did you see the voting list, by the way? One of the bills you testified on.
Oh, awesome. Thank you. Thanks for the heads up.
Thanks. All right. Anyone else? So we have Dominic Buchko, favorable with amendments.
Mr. Chair, members of the committee, Don Butchko with the Maryland Association of Counties, here in support with amendments of Senate Bill 189. Our amendments have been discussed kind of at length. Really, there are certain scenarios where we have land under easement where we might have to put in some critical infrastructure. Important context for this conversation, these lands under easements are not where we want to develop. As some of the witnesses said, that there's hundreds of millions of dollars, potentially over $1 billion invested. From a county perspective, we're not building out the infrastructure that you would have. So like pipes and roads to develop these areas. We put in the investments, the states put in the investments. Our amendments do reflect that there are a very number of limited circumstances where we might have to extend a pipe for wastewater treatment over a couple of feet on a conserved area, not taking the entire area. So noting that there's those one-off situations, that's what our amendments reflect. We urge the committee to support this with our amendments. Thank you.
Questions from the committee? All right, seeing none, thank you very much. With that, that'll end the testimony in the hearing for Senate Bill 189. We'll now move on to Senator Muse, Senate Bill 74.
Okay, good afternoon. Mr. Chairman and members of the committee, for the record, I'm C. Anthony Muse from District 26, and I'm here to present Senate Bill 74. But I would like to request that my intern, Africa, is her name, that she would present this testimony before the committee. Student from Bowie University, majoring in criminal justice, and it's already been a pleasure working with such a brilliant young person who knows exactly what she wants to do in life. She wants to take my place in a couple of years. And so I'm going to ask her if you would indulge me to have her present that bill.
Okay. Good afternoon, Chairman Smith, Vice Chair Walsh-Riker, and members of Senate Judicial Proceedings Committee. SB 74 would change the mandatory judicial retirement age in Maryland from 70 to 75. Maryland's current retirement age from judges was established decades ago, reflecting a different era's understanding of aging and workforce dynamics. Today, this limit is not only outdated, but also detrimental to the judiciary and to citizens it serves. Modern advancements in healthcare, nutrition, and overall quality of life mean that people are living longer, healthier, and more productive lives. The average life expectancy in the United States has increased significantly since the 20th century, and many individuals in their 70s are fully capable of performing demanding roles, including those in the judiciary. For judges whose work relies heavily on intellectual acumen, experience, and wisdom, the capacity to serve effectively often extends well beyond the age of 70. Many esteemed judges report that their late careers are their most productive and insightful periods, enriched by years of legal experience. Maryland's current mandatory retirement age of 70 is one of the most restrictive in the nation. Many states have recognized the outdated nature of this limit and have already extended their mandatory retirement ages beyond 70 or abolished them altogether. 11 states and the District of Columbia do not have any age limits for judges. 7 states have a higher retirement age for judges than Maryland. These states recognize that forcing experienced, capable judges to step down at 70 deprives judiciary of valuable institutional knowledge and expertise. Maryland risks falling behind this trend. Mandatory retirement at 70 unnecessarily removes judges at the height of their careers. Judges bring decades of experience to the bench, and the loss of this expertise can disrupt judicial processes and diminish the quality of decisions. Extending the age to 75 would allow Maryland to retain these seasoned professionals, ensuring continuity and stability in our courts. Furthermore, in nearly every profession, individuals are working longer, employers increasingly recognize the value of experienced professionals and are adapting retirement policies to reflect this shift. Judges with their unique skills, set, and lifetime of legal knowledge are no exception. Raising the retirement age to 75 would align Maryland's judiciary with the realities of modern professional life and workforce participation, ensuring our state benefits from the full potential of its judges. In closing, I respectfully urge a favorable report for SB 74 to support extending Maryland's mandatory retirement age for judges to 75. Thank you.
Excellent.
Mr. Chairman, if I may add on to that, I know that I've read some of the opposition, and the opposition, well-intended, said, well, at age 70, a judge's mental capacity will decrease, et cetera. And I think that's not true. I'll be 67 years old this year, and I plan on being in this Senate when I'm 70. Now, honestly, some have questioned my mental, status but they've done that all of my life, and I'm still here. And I just think I look at our county, and we've lost a lot of good judges. Because you can't beat experience. Experience matters. And across this country, people are realizing that. When I first entered into ministry in the United Methodist Church, the retirement age was 65. And today it's now 74. And so everyone's making these changes, and I think that we need to do the same for our judges, and that's why this is before you, and I request a favorable report.
Mr. Chairman, and very, very well done. I wanted to draw your attention to the fiscal note. it looks like what it says is that the state pension liabilities will likely decrease by approximately 24 million, and the normal decrease cost would be 1.3 million. And when it goes for the out years, it says the likely effect is a decrease of 4.6 million in the state's budget. So it looks like if we did this and gave the judges longer opportunities to
That's
serve,
correct.
we actually would save money as a
Correct.
state. Am I reading that right?
You are, and that's absolutely correct.
Thank you, Senator. Thank you, Mr. Chair.
Who also questions my mental ability, and I'm going to talk to you about that.
You're going to say that, and I'm going to ask this question. So the State Bar Association, in their letter of information, page 2, and I know I've heard bills like this before, and in the past I've generally opposed them. For this reason, it says, by maintaining the current retirement age, judicial diversity may expand to allow new viewpoints and younger lawyers an earlier opportunity to fill judicial vacancies.
Well, I think any profession can say that. You can say that about doctors. You can say that about ministers. You can say that about any profession. It's almost like move them out just to move them out to bring others in. And I think that's very unfair to do. And I don't see a reason in terms of the quality of the court to move this age up. And I understand that younger judges, et cetera, if they just wait 5 more years, they'll still be pretty young.
But unlike those other professions, there are only a limited number of seats or employment opportunities to be named called judges. I think the last time that this was put forth, I think it was called the Miller. Mike Miller he attempted to do it. So.
And I agree with you, and not being, taking it lightly, but the same goes for the Senate and the House. There are a limited number of seats. The same goes for the Supreme Court, where they're able to stay, for a lifetime, and other courts here in our country that have removed those timetables altogether, or that timeline altogether. It still works for the courts, and people are still being appointed.
Thank you, sir.
Thank you. I hope I convince you.
I thought the Constitution said you had to be 35 to run for president, but apparently you've got to be like 85 minimum for president nowadays. So I don't know.
Right, exactly.
So
they can run an entire country.
Yeah. All right. Seeing no further questions from the committee, thank you very much.
Thank you. You did a good job.
Yes, excellent job. Mr. Judicial, you're up next, and then we'll hear from an opposition witness who is testifying virtually.
Thank you. Mr. Chair and members of the senators, my name is Ronald Judicial. I'm a former circuit court judge on Anne Arundel County. I returned to practice in 2011 after leaving the bench, but I am 75 years old, so I would have still been eligible to serve through today. As to the question of younger lawyer opportunities, let me just say this. I was appointed at age 60. If you permit a later age for service, you get more experienced people being appointed rather than young, inexperienced lawyers who go to the bench. When I've returned to practice after age 70, I've handled complicated cases. I've had stockholder derivative action cases. We represented complex personal injury cases, like a boy who got his leg amputated by a riding lawnmower. And I've handled multiple appeals, all after age 70. So many Maryland judges after age 70 become certified by the Supreme Court in order to continue sitting in all levels of the courts, and they fill the vacancies, carry the caseloads. It's very important. It's important to point out that the federal courts have no age limit. And one of the studies, if you see the position paper, I'm testifying on behalf of the Maryland Association for Justice, and we submitted a paper I drafted with a lot of research in it. 10% of the federal judges, who are about 500 and something in number, about 900 number, are older than 85. That's 90 judges who are currently serving that are older than 85 years old. As the fiscal note points out, there's a great savings for the state. And I'll point out some other facts that are in the paper. The 70-year-old age limit was adopted in 1851 by Maryland. Oliver Wendell Holmes, as one of the authors points out, decided many of his important decisions at about age 90. Vermont has an age 90. New York has an age 76. And the practical effect, as many people have said, you lose experienced judges with efficient judges and who bring respect to the judiciary and mentor the younger judges, the newer judges, and all that would be lost, as well as the investment in training those judges. So we ask for a favorable report. Thank you.
Thank you for coming. Just a question. When a judge retires, is that judge able to float or fill in for other judges even though they're at that age limit?
So you get certified by the Supreme Court, Maryland Supreme Court,
okay,
in order to be certified to sit in the counties. For example, the Kent County judge, Judge Bowman, is certified to sit in Anne Arundel County and has been hearing cases here. And Anne Arundel County is backlogged because some vacancies and other reasons.
That's one of my points.
And so that is, and something else to point out, many retired judges go and do mediations and arbitrations. So for example, the Platt Group, which is located here in Annapolis, has 26 Maryland retired judges on its arbitration and mediation panel, and there are other mediation and arbitration panels with retired judges that continue to basically hear cases, but in the context of arbitration or mediation.
Thank you, Mr. Chairman.
Thank you very much, and good afternoon. When I was listening to your presentation, I wanted to make certain that I was understanding it correctly, and you kept referring to federal judges, and I was wondering, are you suggesting that Maryland have lifetime appointments?
Not Maryland, but federal judges are appointed for lifetime.
Right, and what I was asking, are you suggesting that we do the same?
Oh, no. I did point out that since 1851 is when the 70-year-old the threshold was adopted, the life expectancy at that time was 40 years old. The life expectancy today, according to the statistics, is approximately 80 years old. And so in 180 years, to move up 5 years seems perfectly acceptable.
Wouldn't it make sense for society to maybe incentivize people after they've worked for, if you're 70, I'm assuming probably a good 50 years of your life, to enjoy the rest of your life without having to work?
Well, many people enjoy working for the rest of their life.
Very good.
But nevertheless, incentivizing that, certainly getting pleasure time off makes sense. But on the other hand, you're losing some experience in mentoring in your courts, which is very important for the public to get fair and judicious decisions.
Ask Bob Etton and Bruce Boreano that question. They're having the time of their lives right now, right? I'm going to make another joke, but I'm not going to. I'm not sure they heard me, but go ahead, Senator Walsh-Reicher.
Thank you. I'm curious if we have the statistic of those who are forced to retire at age 70, what percentage get certified as senior judges?
I don't know, but the fiscal note points out some statistics about the number of judges who would be eligible for retirement at age 70. I think it was about 75 of the current may not be affected by this bill, according to the fiscal note, and they would then be eligible for appointment by the Supreme Court. Now, many judges don't, like Anne Arundel County Judge Loomis retired to Florida, and it is not certified.
So, yeah, I mean, I guess we can ask the judiciary, but if it's easily accessible, if you can get us the information as to what percentage of judges then certify as senior judges.
I think we can ask the judiciary to provide that information. I'm sure they have it.
And we'll see if we can get the same number from the, because obviously there's no age limit at the federal level, but a number of judges take senior status at the federal level. And I'd be curious as to that statistic as well,
Well,
and comparison between.
and my statistic that I cited, you'll see in my research paper that I submitted, came from the 2023 federal bench summary, annual summary, as to how many judges there are serving in senior status.
Thank you, Mr. Chair. I just wanted to make an observation that if the current system were to continue, and Mr. Enton, Mr. Bariano, and I all got appointed to the bench, we would have to retire immediately because we would have reached the age of constitutional senility. Thank you.
That's true. It's a good man. That was good.
Thank you.
All right. Mr. Barry, you're up. Welcome.
Hi, can you hear me?
Yes, we can. Welcome.
Okay. First and foremost, thank you guys for your time. I'll make this really short. I thank you guys for joking. It looks like the Platt Group is hiring, and maybe some of you guys might need to go over there at the age of 70 and work that way, because I do not favor this, and I'm speaking off of personal experience. Unlike the senator who's proposing this bill or whatever you call it, I was arrested and I had to go before a judge. The judge was a retired judge, and at the time in Anne Arundel County was 73 years old. To piggyback off the last person who spoke in favor of it, that judge, I let him know I wanted to represent myself and that I knew federal law. His direct question to me was, do you know Maryland law? I believe that this is a dangerous yet delicate bill that you guys really need to look into and get more data. It's clear that the people that are proposing it are not aware of how the judicial system works for people who actually have to go in front of those judges. And it's really going to be important that competency is at the forefront, because you're dealing with culture shocks. I'm a woman of color. I'm a millennial. The judges may be 70, 75, whatever the age in whatever state respectively, but back to Maryland. And they may have a disconnect there, and they may be seasoned. But when we talk about extending an age, I'm bringing you guys my situation, which you guys as tax dollars will continue to pay for, because I'm headed to SCOTUS because this judge did not follow protocol. And I can't gauge if it was a issue of discrimination for me being a pro se litigant, if it was his competency, if it was a situation where someone told him to violate my rights. But this judge specifically at the preliminary hearing was a retired judge brought back to the bench at the age of 73. He retired in 2018. So 2022, with his retirement, he probably shouldn't have been on my case. And because of that, the entire state of Maryland, as well as other states, have been caused with a lot of things that won't save any money. It'll only bring more on the back end for those of us who have to fight to rectify decisions that judges have made.
Excellent. Thank you very much, Mr. Barry. Questions from the committee? All right. Thank you. Appreciate you hanging in there with us. All right. Excellent. So with that, that'll end the hearing for Senate Bill 74. We'll now move on to the Vice Chair, Senate Bill 160.
All right, back to real estate. This is actually an interesting issue, Mr. Chairman. Very pleased to present to you Senate Bill 160, which addresses a real estate investor practice often referred to as wholesaling. Wholesaling is actually an assignment of a real estate contract entered into by one party over to a different party who becomes the deed owner of the property. Contract assignments are not widely used, particularly in the residential context, but are now increasing. Why is that? Because there are now real estate investors who are educating other investors about how to use these assignments as investment strategies with residential properties. SB 160's goal is to ensure that a seller or buyer who is dealing with a potential wholesaler is fully informed as to that fact. The seller should know that the buyer of the property, buyer in quotes, does not intend to live in the property and may terminate the sale if the buyer or wholesaler can't find a purchaser willing to pay above the current contract price. On the buying side, a purchaser of the property or their agent will want to know that they are working with a seller or wholesaler and not the actual owner of the property. The bill does not target all contract assignments, but only residential contracts where an owner-occupant lives in the home. If the residential property is non-owner occupied, it is not covered by this bill. SB 160 reflects the bill as amended and passed by the House last year. Although the Bar Association has had input on that version, they may have additional changes that we will work on in the conference room and get everyone brought to consensus. With that, Mr. Chairman, members of the committee, I ask for a favorable report on Senate Bill 160.
Thank you, Mr. Chair, members of the committee. Bill Castelli on behalf of the Maryland Realtors, and we are in support of this legislation. There's not much I can add except maybe give you a highlight of some of the issues that have arisen, and that is in certain instances we've had real estate agents who've been representing a purchaser of property thinking they're dealing with the actual deeded owner of the property, only to find out it's a person who's just assigning the contract. And there are differences between, in a situation like that, between a beneficial owner, who is the person assigning the contract, and the deeded owner. In terms of disclosure requirements that they're required to make, a seller of property has to disclose even to a buyer any material facts that they know of. They would certainly know more about a property than, for example, a beneficial owner of the property would. So there are situations like that. And on the flip side, there are also situations where you've got the owner of that property who may be dealing with someone who's going to assign that contract. So there should be that discussion up front about what that means, what that could entail. If an owner thinks they're selling a property, not recognizing that it could be, or that party might be trying to assign it, and then they can't find a party to pay above that contract price, then that transaction may not go forward. So those are the kinds of issues we're trying to address, and just make sure that parties are informed when they're in those transactions.
So, Mr. Castelli, let me ask these questions of you. When I was 9 years old, I went out to spend the night with my first cousin. And the following Saturday morning, his father, my uncle, threw us all in the station wagon and drove us out into Howard County. And we played in a little stream, looked for tadpoles, while my uncle walked around with the owner of the property, examining the property. Later on, when I graduated from high school, my uncle was at the house for the graduation party after the graduation ceremony. And he said, "Do you remember that time when you're 9 years old?" And I said, "Yeah." And he said, "Do you know where we were?" And I said, "No." And he said, "Well, where we were is currently underwater. It's called Lake Kittamaqundi. My uncle worked for the Rouse Company, and he was one of the people who went out and bought property in Howard County, fully intending to transfer the contract of sale to the Rouse Company so the Rouse Company could acquire the city of Columbia. And that's how the city of Columbia came to be. All these people went, if they had disclosed to the purchasers that were disclosing as a part of a major property acquisition, the price of the property would have gone way up, and the city of Columbia never would have been built. So how would this, if this bill had been in effect back then, do you think this bill would have prevented the city of Columbia ever from having been built? And if you agree with that, do you still think this bill's a good idea?
So I don't think that probably would have impacted the future development. It's a question of, would parties have paid more? Would there have been more negotiation between the seller and the buyer? But given the fact that Maryland is a small state that's very densely populated, there really aren't large tracts of land. That's why I think that developments, large-scale developments like that, to the extent that they could occur in Maryland, probably would still occur. It's just a question of whether it would have been more expensive, those things moving forward. That's speculation on my part.
Yeah, of course, but interesting speculation. And I think we should think about those sorts of consequences as we consider this bill.
Yeah.
Thank you very much.
Sure.
Good, but just in following the senator's scenario, but couldn't that same scenario happen just by creating a number of LLCs or some other business entities? And so you don't necessarily, this or the passage of something like this wouldn't necessarily hinder what Mr. Rouse did back then of something today, correct?
I think that's a good point. I do think that's a more typical scenario in a development process where lots would be assembled through LLCs, but yes.
And just so that, tell me again, when does one usually use this type of vehicle and the ultimate buyer, am I correct, they actually will end up with the property because because of the contract assignment? How does this work?
So it would typically work, the wholesale seller and buyer, typically the same person. They would approach a property owner, and again, we're really targeting folks who are living owner occupants of their homes. We're not trying to get investors who are trying to move vacant, blighted properties, things like that. Basically, the contract would state that this property may be assigned. Hopefully, there's a conversation about what that means. And generally, that person who is going to be the wholesale buyer in that case is then going to look for an investor in that property. And that investor of the property is really going to be the ultimate purchaser of the property that's going to move into it or hold it for investment purposes. And then that investor, wholesaler, has got to have a disclosure with that person, just letting them know, hey, I don't really own the house. I have a beneficial interest because I have a contract on it. And then they have an agreement that whatever the deeded owner and that wholesale buyer agree to, that this price is going to be something X above. And where we've seen situations where like owners who haven't been informed about that, and then suddenly there is a huge delta between what their contract said and what the ultimate purchase price of the home, that's when, you know, sellers have had regret, which is why it's important that they're informed about it.
And by delta, you mean change?
Yes, delta and change, yes. So significantly above the price that they sold.
Thank you.
Chairman, and thank you for your testimony.
Sure.
I'm trying to reconcile what sounds like a whole industry into itself, and then it sounds like it may be in competition with your industry, with realtors. If you have these sort of broker middlemen who are approaching people and they are purchasing property and then selling it as investors to someone else, it sounds like that has the potential to kind of cut out the realtor who would make a sale, make a commission on a contract. I want to make sure I understand the competition and the symmetry between your industry and the wholesale industry.
Yeah, it's possible that that could be true. I will tell you that in some of these transactions, real estate agents have been part of it, not only as the wholesale representative, but also just representing a buyer in a normal transaction, but ending up dealing with a wholesaler. Or on the flip side, representing a seller who then gets approached by an investor wholesaler. So it's not as clear cut as that, but that could be true too.
Would the bill have a chilling effect on the wholesale industry, or would it promote additional growth in the wholesale industry?
I don't know that I could say that. I mean, we met with representatives of the industry when we were putting the amendments together, and I think they're looking for a best practices, making sure disclosure occurs up front too. So they were part of the group that worked on the amendments last year with the House Committee when it was reported out.
You mentioned that the goal is to not stop the work that's happening in blighted areas, because we as government, we have limited measures that we can take. We see a community in blight, we want to, fix it up, but we need to rely on the private industry to be an important part of that. And the wholesale market is an important part of that ecosystem. What guardrails are in the bill to make sure that we're not taking away from that important work?
So what the bill tries to target is an owner-occupied property, because that's where there is theoretically more of a potential consumer harm. So we're not trying to deal with, so if it is a vacant property, if there's no owner occupant in the property, so it's clearly just an investment property, those would not be impacted by the disclosure requirements in the bill.
Thank you. Thank you, Mr. Chair.
All right, thank you very much. Thank you.
Thank you. Thank you.
Thanks. All right, that'll conclude the hearing for Senate Bill 160. We'll now move on to Senator West for the rest of the day. Senate Bill 12.
Thank you, Mr. President. Mr. Chair, could I bring up here all the people who can testify on all these bills? Because they're sort of, they're interspersed. Thank you. And I hate to inflict Senate Bill 12 on you first, because Senate Bill 12 is far and away the most difficult of all the bills. Once we get past this one, the bill should be very easy, and we'll go quickly. The reason why this is difficult is because it deals with very complex subjects. In particular, we're dealing with the federal estate tax laws as well as protections from creditors. So currently, 10 states have this bill, Senate Bill number 12, as a matter of law. So Maryland won't be alone. Delaware, for example, has it. I think Florida has it. Other states nearby and far away have this bill as a matter of law. So let me talk about the concept here, and then quickly I'm going to turn this hearing over to my witnesses who understand it much better than I do. So we're talking here about people with money, a lot of money, and they want to protect their money from it disappearing when they die to the Internal Revenue Service through estate taxes. There are various ways that this can be done, and the Maryland law currently provides various possibilities. One possibility is to convey their property into a trust. And the trust would be for the benefit of another, most typically the spouse of the person putting the money into trust. This is permitted under Maryland law right now, and if you do it in the right way, the property that you convey into trust would not be taxable by your estate when you die, and your creditors would not be able to get at the property while you're still alive because you've properly put the money into trust. Good estate tax lawyers know how to do this and how to make it work. So we have right now in Maryland law something called a lifetime qualified terminable interest property trust, referred to as a Q-tip trust. And if a person in Maryland, following the advice of the estate tax lawyer, creates a proper Q-tip trust and puts assets into a Q-tip trust, when that person dies, the money will not be taxable to the estate, nor will creditors be able to get at it. The wrinkle in this comes when the property is transferred to a trust for which the beneficiary is a spouse, and when the spouse dies before the person who created the trust. That creates an interesting situation, because if the spouse's will provides that that property would come back to the original person who put the money into trust, the possibility exists that if it's not done properly, the property would be taxable for estate tax purposes when the person who created the trust died. So if a Q-tip trust is done correctly, you can get away from, you can avoid that happening. When the spouse dies and the property now comes back into the possession of the original owner of the property, you're avoiding the deleterious consequences. I hope I've said this correctly, but I wanted to set up for you what we're talking about here are trusts set up by wealthy people in order to avoid federal estate tax and to avoid having property being subject to their creditors. And in the case of one of these trusts, we're talking about the spouse dies, and now the property comes back into the hands of the person who put the property into trust. The reason why this is important right now is because the current exemption from federal estate taxes is in round numbers $14 million. But on December 31st this year, unless the Congress changes it, that $14 million turns into, as I believe, $7 million. So there are a lot of wealthy people right now who are consulting estate tax lawyers to try to figure out how they can take advantage of the $14 million exemption today and not all of a sudden find it's only $7 million as of the end of the year. What can they do now to protect that money of theirs from being heavily taxed upon their desks? And they need to do it before the end of the year. Currently, there is another form of trust which these other states have called spousal lifetime access trusts, or SLATs. Not Q-tips, SLATs. And currently, Marylanders with a lot of money can hire lawyers in those other states which permit SLATs and use those lawyers to draft estate tax provisions for them, which will be valid. So one reason for this bill is to keep that work here in Maryland, to keep that legal work here in Maryland and not have it flee to other states and lawyers in other states. So with that, I'm going to turn this over to my witnesses, and I hope that you'll give the witnesses the time they need to explain why this bill is necessary. And then if you have questions, probably the witnesses will answer them better than me. Thank you.
Thank you. Can you hear me? Thank you, Chair, Vice Chair, and distinguished members of this committee. My name is Leanne Broyles. I am an estate and trust practitioner here in Annapolis, Maryland, and I am testifying in support of Senate Bill 12 on behalf of the Maryland State Bar Estate and Trust Section. And thank you for the introduction of that bill. I think you did a great job. There are a couple points I'm going to clarify a little bit as we go through, and I want to explain a little bit initially how a SLAT works, or the Spousal Lifetime Access Trust, how it works, and then my colleague Laura is going to talk more about the bill. So Senate Bill 12 seeks to amend Maryland Code Estate and Trust Section 14.5-1003 to provide these spousal limited access trusts the same protections under Maryland law, which are currently allowed to qualified terminable interest property trusts. And right now we can do SLATs in Maryland, and these are a very commonly used estate planning tool. But the Maryland law regarding SLATs and with respect to who is considered a settlor of a trust sort of has a gap in it that does provide protections to Q-tips, and that's what's missing for the SLATs. So that's what we're trying to achieve. So what is a SLAT? A SLAT is an irrevocable trust that's created by a settlor. That's the person who creates the trust for the benefit of his or her spouse. Sometimes a SLAT includes other beneficiaries as well. Generally, the purpose of creating a SLAT is to utilize the settlor's federal estate and gift tax exemption, around $14 million, and to protect the appreciation on the assets that are transferred into the SLAT from the federal estate tax, while at the same time providing the settlor's spouse with access. Am I done?
Why did I finish that paragraph?
Oh, okay. While providing the settlor's spouse with access to the resources during their lifetime. The way it works is when this trust is created, the settlor's estate and gift tax exemption is applied to the gift based on the value of the trust assets at the time of the gift. The settlor doesn't continue to be a beneficiary of the trust. It's his or her spouse and potentially the third parties. By virtue of that, the assets in the SLAT are protected by the creditors, or from the creditors of the beneficiaries of those individuals. Should we switch?
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Laura Thomas, and I'm the chair-elect of the Estate and Trust section of the Maryland State Bar Association. So to pick up where my colleague left off, the issue really arises, as Senator West said, when the beneficiary spouse passes away before the person who created the trust. These assets are not available to the marital unit anymore as a way to support them. And if the trust document gives the spouse the ability in their will to say, I'm giving an interest in this trust back to the person who created it, we run into a situation where it's possible that the assets in the trust at the time of the creator's death are then included in their taxable estate for estate tax purposes, even though they've already applied exemption to this trust during their lifetime. What this does is increase the overall tax burden on the estate. And as Senator West said, in other states, they have remedied this situation by giving SLATs the same protection as we've given Q-tip trusts under Maryland law already. The way a Q-tip trust differs from a SLAT is that both are primarily created for the benefit of someone's spouse. SLATs allow for other beneficiaries in addition to the spouse and don't require that income be paid out on a regular basis like a Q-tip trust. Q-tips are a specific type of trust that have to meet requirements under the Internal Revenue Code. So we've already provided for the protection of an interest in a Q-tip that a spouse gives back to the person who created the trust after their death, and we are asking that that same protection be extended to the creators and spouses of those creators of spousal lifetime access trusts. Thank you for your time, and we respectfully request a favorable report on this bill.
Now, if anybody has a question, I'm probably going to defer to my witnesses.
We're gonna workshop this because I have tons of questions, but like a lot.
Yeah, and I will get the witnesses to come to the workshop so they can contribute to the conversation.
Just one, what is the springing event for the SLATs trust then? Because if the creator of the trust dies, then it's subject to an inheritance tax or the estate tax.
So if the creator of the trust dies either
before the spouse,
if they die before their spouse, it's not included in anyone's estate because they've applied their gift tax exemption to it during their lifetime.
Okay.
And at the federal level, the gift and estate tax exemption is one combined exemption. We just refer to it differently, whether you're using it during your lifetime or at death. So if the person who created the trust dies first, it's not includable in the taxable estate of the person who created the trust or their surviving spouse.
Got it.
It's only if the creator of the trust dies after their spouse and the spouse has, through their will, has given them an interest in the trust for their remaining lifetime.
Got it. So we're going to do like a decision tree for this whole thing. This discussion.
I said I'll send a diagram.
That'd be very helpful.
All right.
Okay. Thanks. Further questions from the committee? Oh yes, Senator Henson.
Thank you, Mr. Chairman. I don't know if it's more of a comment than a question, but as I listened to the testimony, I thought, so we are creating a structure where a person who gets to enjoy the benefits of being wealthy during their lifetime, and you can do all the things you do with that, all the inter vivos transfers you might make to family members. You have this ability to protect your spouse and to further, protect and isolate that money and that wealth. And then the estate taxes, all the things that happen, certain portion you get to continue to protect. And then you create all these creative kind of workarounds to figure out how you take those resources and you further concentrate them. And it's like a philosophical question of at what point is enough for one person? And at what point do we create additional opportunities for other people to benefit from wealth additionally, or do we continue to create a system where we kind of trap those resources in the hands of a few and provide very little off-ramps. So I think that's my thinking when I think of the bill. It's kind of a philosophical debate between two different ways of viewing resources and accessibility to them. But I do think that's more of a comment than a question on the technical component. So I appreciate your indulgence. Thank you.
All right, any further questions for these witnesses? Of course.
Question. The people who will take advantage of these spousal lifetime access trusts are people with a lot of money. But because the people have so much money, they can afford to hire very good lawyers to try to protect their assets. And there currently is a route for those people to protect their assets, and that is by going to other states and using laws on the books in other states to do it, which then denies business for Maryland lawyers and suggests to people, it's just one more reason to people why they should think of leaving Maryland with wealth rather than staying here. So this bill doesn't increase their options, but increases the probability that they will exercise those options while continuing to reside here in Maryland and using Maryland lawyers.
Great. Okay. Seeing no questions about SB 12, do we have opposition? I don't believe so. Okay, well, that concludes the hearing then for SB 12. Next on the list, we have SB 19, Senator West, if that works for you.
Thank you, Mr. Chair. And I will say that from this point on, I think the bills should be relatively quick. I'm not aware there's opposition to any of the additional bills, and they're relatively easy to explain. Let me start with Senate Bill 19. This deals with compensation paid to guardians and to trustees of trusts. I want to make it clear the bill does not in any way change the current compensation scheme for guardians. Because the current compensation for guardians merely adverts to the compensation scheme for trustees, and because this bill does change the compensation process for trustees, we're replicating in the existing statute the existing compensation scheme for guardians. So it looks like we're doing a lot for the guardians, but in fact, we're simply replicating what's already there. So we're leaving the compensation formula for guardians identical to the way it is now. What we are changing in this bill is the compensation for trustees. So under the current law, a trustee, which is a financial institution or is a member of the Maryland Bar, can file a schedule of rates to govern the payment of compensation by the trust. This would override the rate scheme that's set forth in the statute, which has been there for many years, and many people feel grossly underpays trustees for the work that they do. So in cases of Legion, where financial institutions who are trustees or members of the bar who are trustees feel that the statutory compensation is inadequate, they're permitted to file a schedule of rates. And in those cases, the schedule will apply unless one of the beneficiary files a petition with the court to review the reasonableness of the rates in the schedule. So currently, people who are not financial institutions or are not members of the Maryland Bar are governed by the statutory rates, and that can result in them receiving commissions that inadequately reflect the work that the individual trustee did during the year. So Senate Bill 19 resolves this problem. For guardians, it retains exactly the same formula for right now, so it doesn't touch them. For trustees, it removes the commission calculation, which is based on income and principal, set forth in great detail in the statute, and replaces it with a standard of reasonable under the circumstances, as determined by a court with jurisdiction over the trust. Now, insofar as an individual trustee is concerned, the individual trustee will be able to receive reasonable compensations that reflect the work the individual trustee did on behalf of the trust each year. Insofar as trustees who are members of the bar or financial institutions are concerned, we still give them the right to have a schedule of fees applied. And then the notice is given to the qualified beneficiaries, and they have the right in turn to come into court and to oppose the proposed fee schedule, saying that it's too generous. So in either event, 1/2 of the compensation paid to a trustee will be allocated to the income of the trust, and the other half gets allocated to the principal of the trust. And to testify, to help me out on this, is Bob Horn, who is a practitioner of estates and trust law. By the way, all the bills on my pile today were brought to me by the Estates and Trust section, except one bill brought to by the Register of Wills of Baltimore County. So I didn't dream these bills up myself. I'm trying to help the Estates and Trust section of the Maryland Bar Association. It's one of the bar's substantive law sections. Each of the substantive law sections is comprised of leadership drawn from the best practitioners in that area of law across the state. And they've been very helpful to me over the years, and in fact to the General Assembly over the years. So with that, I'm going to turn it over to Bob Horn to further explain this bill.
Good afternoon, Mr. Vice Chair. Mr. Chair is not here, and the members of the committee. My name is Robert Horn. I'm an attorney at the Penninger Law Firm, and I'm here today, as Senator West said, on behalf of the MSBA's Estates and Trust Section Council. And I appreciate Senator West for his kind words about our section, and we think very highly of you. Thank you. I've submitted my written testimony, and just to sort of, and Senator West hit on a lot of the topics that I already discussed, or that are discussed therein. Sort of the high point, bullet point issues here are, one, again, the guardianship statute, although there's a lot of wording there, essentially we're just taking what was currently in the Trust Act and putting it in the guardianship compensation provision. So it's intended to be without change. There is, in fact, a task force currently convened working on a comprehensive guardianship bill that probably won't show up until next year, but its guardianship stuff is shelved for the time being. Also, as Senator West pointed out, this really only impacts individual trustees. And an individual trustee here is someone who's not a member of the Maryland Bar and someone who's not, we say financial institution, but it's a trust company. And a trust company has a very specific definition under Maryland law. It's not just any small business. You can't just form an LLC and say, I'm a trust company. There's capital requirements and registration requirements and certain things of that nature. So again, we're dealing with individual trustees who may be, frankly, it's your uncle, it's your cousin, it's your friend who is serving of a smaller trust that's created for a special needs person, or someone who isn't going to get an institutional trustee consideration, and the trustee has to do a lot of work. And an example of some of the services trustees provide. They are valuing assets, real estate. They sometimes have to sell them, sometimes have to buy them. With that said, I hear my time is up. I'll take any questions you may have. And again, we strongly urge the passage and a favorable committee report from Senate Bill 19. Thank you very much.
Thank you. I also have a Ms. Emick signed up to testify. Why don't we take your testimony and then we'll do questions.
Thank you. Thank you, Mr. Chair, Vice Chair, and the members of this committee. My name is Jenna Amick, and I am a staff attorney at Maryland Legal Aid. Maryland Legal Aid submits its written and oral testimony on Senate Bill 19 in response to a request from Senator West. Maryland Legal Aid is the largest nonprofit law firm in the state of Maryland. We provide court-appointed representation to alleged disabled persons in guardianship proceedings in multiple counties in the state. Many of our clients in these proceedings also face petitions for appointments of guardianships of property. Guardians of property are responsible for managing property and benefits when someone with a disability is not able to effectively manage their own finances and affairs. We support a clear method of compensation for guardians of property. In too many of our cases, courts have struggled to find a prospective guardian of the property and actually end up appointing petitioner's counsel as the guardian of property for our client, which is not favored because then the opposing party's counsel is now in control of our client's funds. We believe that with amendments, this bill would protect the income of our clients who are among the poorest of individuals who have guardians appointed in Maryland. Right now, the compensation structure would allow a guardian to seek 6.5% of the first $10,000 of all income collected each year from any source other than real property. Many of our clients only receive income from Social Security, either SSI or SSDI. The maximum monthly SSI benefits are $967 for an individual. That amounts to $11,604 a year. And as a result, a guardian of property could seek over $750 a year from some of the poorest individuals in the state who are disabled and under a guardianship. We would suggest amending the bill to exempt up to $1,000 per month of Social Security benefits, both SSI and SSDI, from the income calculations in this bill. This would protect individuals under guardianship who have the least resources while still allowing guardians of property to be compensated for their services. Thank you.
Thank you. Any question for the sponsor or these witnesses? All right, seeing no questions, that concludes the hearing on SB 19. Next is Senate Bill 110, Senator West.
Senate Bill 110. Let me find it. 26. Would be at the bottom. There it is. Okay. Thank you, Mr. Chair. It's a pleasure to present Senate Bill 110. This involves priority of claims on the estate. This is the bill that was not brought to me by the Estates and Trust section. It was brought by the Register of Wills of Baltimore County. And the Register of Wills is sitting next to me right here. So let me explain the bill. It's very simple. Under current Maryland law, when distributing money from a decedent's estate, there's an established list of payment priorities. And these come into play when there's not enough money in the estate to pay all the claims against the estate. So, as long as the estate's money lasts, the following claims against the estate are paid in this order. Number 1, fees due to the Register of Wills. 2, the cost and expenses of the administration of the estate. And going on, funeral expenses, the expenses of the estate's personal representative, a certain family allowance, taxes that are due, medical expenses associated with the decedent's last illness, up to 3 months' rent, money for services performed for the decedent for the 3 months immediately prior to death, claims for certain public assistance, and finally, all other claims. Currently, unpaid child support falls into the all other claims category, along with credit card balances, unpaid electrical bills, and the like. The theory of this bill is that unpaid child support should receive a higher priority than unpaid electrical bills. So this bill simply inserts claims for unpaid child support into the priority list at the 6th position, prior to taxes and medical expenses and rent and all other claims. This is a simple but necessary bill that will help to better ensure that Maryland's children are properly cared for. These children have suffered the loss of a parent. They should not simultaneously suffer the loss of child support to which they're entitled for the period prior to the parent's death. Now I give you the Register of Wills of Baltimore County, who's going to talk about the bill a little further.
Thank you to the committee, and thank you to the chair's not here, so Vice Chair Waldstreicher. Excuse me. I'm the Register of Wills for Baltimore County, and I'm here to urge a favorable report from the committee for Senate Bill 110, and I'm very grateful for Senator West for sponsoring this bill. I think it's a simple bill that could really impact families across the state of Maryland, and this issue doesn't come up every day with the Register of Wills, but when it does come up, it's always tragic that a credit card bill would have the same priority as a claim for unpaid child support. So Senator West did such an excellent, thorough job in explaining why this bill is important and the legal framework for it. I will just submit to your questions going forward.
Sounds good. Senator Love.
You have the gavel, so you are the chair, so thank you, Mr. Chair. How did you come up with the 6th slot? Why is child support payment below commissions of real estate brokers? So
the 6th slot and this order of priority mimics the federal bankruptcy code. So that's where the 6th slot, that's where that came from. Other states handle it differently. In Delaware, for example, claims for unpaid child support is actually 3rd, so right behind family allowances, and it has a higher, and fees to, and funeral expenses So Delaware has it third. Pennsylvania doesn't allow any special treatment for claims of unpaid child support. Virginia, it's actually eighth, but under the federal bankruptcy code, it also appears right above taxes. So that's where that came from.
Got it. Thank you. Thank you, Mr. Chair.
Thank you. Any further questions? All right, seeing none, thank you, Senator West. That concludes the hearing for Senate
Thank you
Bill
to the committee for your time.
110, excuse me, and we will next go to Senate Bill 126, Senator West.
126. Here we go. Thank you, Mr. Chair. This is a very simple bill. Senate Bill 126, again, was brought to me by the Estates and Trusts section of the Maryland State Bar Association. Under the current law, unless a trust agreement specifies the method by which a trustee can resign from his or her position as trustee, in every case, a court must approve the resignation of the trustee. This causes expense and time. In nearly all trust agreements prepared in recent years, a provision is included in the trust instrument stating that the trustee can resign after due notice to the appropriate parties. However, many older trust instruments do not specifically state that the trustee can resign, and in these cases, the trustee must petition the court to approve the resignation. Petitioning the court can result in increased trust administration costs, as well as a delay in the effective administration of the trust. This bill merely adds to our law an additional method for resigning as trustee. Under this bill, a trustee will be able to resign with 30 days' notice to the qualified beneficiaries of the trust, the settlor of the trust if still living, and all co-trustees of the trust, and any person that currently has a right to replace or appoint a successor to the resigning trustee. So this bill fixes a minor technical glitch that currently exists in our estates and trust law. And I think we have Leanne Broyles with us to testify to add gloss to this bill. Thank you.
Thank you, Senator West, and thank you, Vice Chair and members of the committee. Again, I'm Leanne Broyles, testifying on behalf of the Estate and Trust section of the Maryland State Bar Association in support of Senate Bill 126. I think Senator West explained the issue pretty well. Our current law states that a trustee may resign on court approval, and drafters of trusts can draft around this, but there are a lot of older, outdated trusts that don't have any provisions regarding procedure for trustee resignation, and in those circumstances, the trustee would need to go to court to resign from the trust, and this leads to a lot of increased administration costs and delays in effective administration of the trust. So the proposed legislation seeks to fix this problem by providing that a trustee can resign after within 30 days or when 30 days pass from notifying the qualified beneficiaries of the trust, the settlor, if they're living co-trustees, and any other people who have the right to replace or appoint a successor. Passing this law would preserve trust assets in the circumstances where there's no provisions about resignation. So thank you, and again, we urge a favorable report on this bill.
Thank you so much. Mr. Enton, you are...
Yes, Mr. Enton also has signed up to testify.
Please. Mr. Enton.
Mr. Chairman, thank you very much. Robert Enton on behalf of the Maryland Bankers Association. And we're here in strong support for the bill. And, you heard the testimony from the Estates and Trust section. And number one, I want to publicly thank the Estates and Trust section for reaching out to me on behalf of the Maryland Bankers Association to, let us know what bills they were putting in this year and to get our comments and thoughts. This is an interesting bill because going back, some of you know I've been doing this for a long, long time. And, in the old days, we had Equitable Trust Bank, okay? We had Mercantile Safe Deposit and Trust Company. And banks have, for decades, have engaged in acting as corporate fiduciaries for trust. So we have instruments out there that are very, very old. Trusts were created decades ago. The bank is named as the trustee, and this kind of, separates out what they have to go through, makes them basically go to court to try to get, if the trust, if no longer makes sense to have the trust, it no longer makes, you don't need a bank to manage it, maybe the assets have dwindled, whatever. So we strongly endorse this bill, and we hope that you'll give it a favorable report. Thank you.
Thank you. Questions for Mr. Enton or anyone on this panel or the sponsor? All right, seeing none, that concludes the hearing for Senate Bill 126. Thank you all. Senator West will move now to Senate Bill 135, attorney-client privilege. 135.
Thank you, Mr. Chair. This is another bill that was brought to me by the Estates and Trust section. As you can tell as we go through these bills, most of them fix little glitches in the law. This does too. So Maryland has, is everybody here a lawyer? The non-lawyer is leaving, so I was going to tell you what the attorney-client privilege concept is. But as long as everyone here is a lawyer, I know all the lawyers are familiar with the attorney-client privilege, so I won't do that. Maryland recognizes some limited exceptions to the attorney-client privilege. However, a fiduciary exception is not among them. The fiduciary exception to the attorney-client privilege, which is recognized in a minority of states, allows the beneficiaries of a trust to discover communications between the fiduciary of the trust and the fiduciary's counsel generated while administering the trust or the estate. So when this happens in these other states, when beneficiaries can invade the attorney-client privilege, it causes a breakdown in the attorney-client relationship between the fiduciary and the fiduciary's counsel. Now, Maryland case law and statutes do not clearly state that Maryland does not recognize this privilege, rather this exception to the privilege. And as a result, in litigation, parties often raise the issue, and it causes increased cost and delayed adjudication in many cases. So this bill would simply add a section to the Estates and Trust Code that makes it clear, like in most other states, that Maryland does not recognize the fiduciary exception to the attorney-client privilege. I note there's no opposition to this bill, and with me is Deb Howe, and she's going to tell you a little more about it.
Good afternoon, Chair Waldstreicher and distinguished members of the committee. Thank you for your time. As Senator West noted, my name is Deb Howe. I'm a trust and estate practitioner here in Maryland, and I'm here on behalf of the Estates and Trust section of the Maryland Bar Association asking for a favorable report on Senate Bill 135. Like Senator West, I will not explain the attorney-client privilege in a room of experts. However, I will note that it dates back to ancient Rome and that it was well established by the 16th century in English common law. Needless to say, the attorney-client privilege is an incredibly well-established principle in U.S. law. So what we're dealing with here is a little bit of uncertainty in Maryland law about whether it applies in the fiduciary situation. Senator West noted that the impact can be increased cost in litigation as well as delay. I will note the additional impact before and maybe when litigation never takes place of uncertainty on behalf of the fiduciary. Will my conversations and my communications with my attorney at some point be exposed? The one of the origins of the attorney-client privilege is the idea that we need to encourage candid and thorough communications between a client and their counsel in order to have the best advice from the attorney. So in order to protect that, in order to get rid of the uncertainty about whether this privilege does apply, we would ask for a favorable report on Senate Bill 135, which clarifies Maryland law that there is no fiduciary exception to the attorney-client privilege. Thank you so much.
Thank you. I also have Mr. Enton signed up for this, so before we get to Senator Love, Mr. Enton.
Thank you, Mr. Chairman. Robert Enton, once again, on behalf of the Maryland Bankers Association, supported this bill. I mean, I had no idea about this until I read the bill, and it just seems really strange to me that there would be an exception to the attorney-client privilege in this type of situation. And once again, we serve as fiduciaries. Not everyone who's in the trust department of a bank is an attorney. They go to outside counsel for advice, and why shouldn't those communications be privileged? So we support the bill. Thank you. I'm happy to answer any questions, but I'm not the expert on this. You have the expert here.
Sounds good. Let's go to Senator Love.
Thank you, Mr. Chair. I'm a little confused that there's confusion. It's not often that we have to put in code, we don't mean this. And so I guess I have a couple of questions. Why is there confusion? Because there is no such exception. So clearly, if there's no such exception, there shouldn't be an exception. So that's my first question. And my second question is, do you know any other place in the law where we say this exception isn't in law, so we mean we don't have this exception?
So for the first question, the first states that started recognizing the exception to the attorney-client privilege did so at common law. It was in the 1970s. So in other words, case law. Cases or states' jurisdictions that did not specifically say whether or not there was an exception to the attorney-client privilege had a legal analysis in a case. I think this started with the Riggs case in DC, actually, where they analyzed a number of factors and decided that the attorney-client privilege did not apply in a specific circumstance. So it was actually case law that gave rise to this exception, not statutory law. So that's where the uncertainty arises. And I'm going to ask for a little bit of clarification on your second question. I didn't quite follow it.
Well, it seems to me what we're saying is, if we were to pass this bill, we would say, we don't explicitly put this in our exceptions, and we mean it's not an exception. I mean, that's in essence what we're saying.
That's correct.
Do you know anywhere else in our code where we're saying that type of thing? We don't say this in law, and we mean we don't say this in law.
So a clarification that something is not an exception. I know of other jurisdictions that have codified this exact fact that the fiduciary exception to the attorney-client privilege is not recognized in that state. So for example, New York, and I mean, we probably looked at 5 or 6 other jurisdictions that had codified it when we were drafting this particular legislation. I did not look at other examples in Maryland where we had codified the lack of an exception. I could certainly look for that. I'm not sure off the top of my head of the existence of that in the code, though.
That's okay. If you could get us those other states, that would be helpful.
Absolutely.
Thank you. Thank you, Mr. Chair.
Thank you. Senator Sidnor.
Thank you. And just to make certain that I'm clear, this, I mean, I'm reading the fiscal note. It says that this bill establishes that unless waived by the client, the communication between an attorney and the client that acts as a fiduciary is subject to the attorney-client privilege. And then when I look at lines 16 and 17 as to the definition of fiduciary, it refers us back to 17-101. And I think Mr. Enton had noted that sometimes, I guess many of the people that would then be, brought in to the statute would be non-attorneys?
It's certainly possible. To serve as a fiduciary, for example, a trustee, you are not required to be an attorney. It's not uncommon that attorneys do hold that role, but a layman could serve as a trustee, a trust company or other financial institution could serve as a trustee. This is not limited to whether or not the individual is a trustee. What it applies to is when that individual, whether it's an attorney, a layman, or a trust company, seeks legal advice, is that communication with that attorney who is not the trustee, is that privileged?
Say that one more time for me.
So regardless of who the trustee is, whether they're an attorney or a layman, when they go to an attorney and seek advice, that conversation is privileged, and that's what this bill is addressing. So it doesn't.
You want it to be privileged.
I'm sorry?
You want the conversation to be privileged.
Correct. So the bill clarifies that that conversation is privileged, as would any other conversation between an attorney and the client, unless it is otherwise waived.
Okay, so we're extending an attorney-client privilege to non-attorneys?
No. So the conversation is still between a client and an attorney. So what I'm saying is it doesn't matter if the client also happens to be an attorney or not. Just as if I meet with my individual clients to prepare an estate plan, that's a privileged conversation. If my client happens to be an attorney, it's still a privileged conversation. So it's not an extension of the attorney-client privilege. It's simply clarifying the attorney-client privilege would apply in that situation.
I guess I'm trying to get my mind wrapped around the reference to fiduciary, which includes agent, and agent's definition is a person granted authority to act for a principal under the power of attorney, whether denominated as agent, attorney in fact, or otherwise. Which means it could be a whole swath of people. So I guess what I'm trying to understand.
I think I see your question, Senator. So the fiduciary, attorneys operate in a fiduciary capacity, but when we're talking about the fiduciary in this case, we're actually not talking about the attorney. We're talking about the client, who happens to be a fiduciary because they're the agent under a power of attorney, they're the trustee of a trust, et cetera. So they're serving in a fiduciary capacity, and when that fiduciary goes to a lawyer and talks to a lawyer, that's the attorney-client privilege we're talking about.
Thank you.
Absolutely.
Thank you, Mr. Chair. Apologies for the second question. Something that you just said triggered a question. Who is the client in the case of a trust? Is it the trustee? Is it the beneficiary? Is it the trust entity? Who is the client?
Good question. So much of this can actually be determined by the way the representation is set up. For example, how the engagement proposal is worded, and how the how the conversations are started. However, in this case, if a trustee, in the case of the legislation, if a trustee goes to an attorney and seeks legal advice, the trustee is the client in his capacity as trustee. And that analysis of who is the client, who's paying, et cetera, that's some of the case law that gave rise to this uncertainty, because the analysis in a minority of jurisdictions has led to the conclusion that in narrow circumstances, the fiduciary there is an exception to the attorney-client privilege.
Got it. Thank you. Thank you, Mr. Chair.
All right, further questions from the committee? All right, seeing none, thank you all. All right.
Chair, I've got two more bills.
Excellent. So we're now on, are we on Senate Bill 135 now, or that was it? So we're on Senate Bill 158 now.
158, okay. Thank you, Mr. Chair. It's a pleasure to be here to present Senate Bill 158. So the committee, those members of the committee who were here 2 years ago, and there are only two of them in the room right now other than me, will maybe recall the Trust Decanting Act. Oh, three? I'm sorry, there are three. This was the deal where the trustee of a trust realizes that the beneficiary of the trust is either impecunious or is irresponsible or has lots of debts, and the trust is about to expire. And so the trustee of the trust creates a new trust and pours the assets of the existing trust into the new trust for the benefit of that beneficiary, so that the trust assets won't be frittered away or taken by creditors, as the trustee concludes the original settler would not have wanted. So we passed that bill a couple of years ago. So why am I back here today to talk about decanting? And that is, the bill that we passed 2 years ago did not include a list of the methods of notice that a trustee must use to ensure proper notice to the individuals who should get notice. The thought was that the notice requirements in the overall Trust Act would apply. But because the Decanting Act was put into a different part of the code, the normal provisions for notice that are in the Maryland Trust Act didn't apply to it. So the reason for this bill is to add to the decanting bill that we passed 2 years ago the same notice requirement that's currently contained in the Maryland Trust Act. And that's all we're doing. We're adding a notice requirement so that if a trustee wants to decant the assets of a trust, the statute will now prescribe precisely who should get the notice of what the trustee proposes to do. And with that, I turn my hearing over to Ms. Broyles.
It's me again. Thank you, Chair, Vice Chair, and members of the committee. Senator West, again, explained this issue pretty well. We have a hole in our decanting statute. Basically, the decanting statute stipulates that a trustee must give notice to certain individuals when a trustee is going to exercise the power to decant, but the decanting statute doesn't say what those methods of notice are, so how to give the notices. And again, the issue arose because both of these statutes, this statute came from the Uniform Decanting Act, and there's also a Uniform Trust Act, and under the uniform laws, they're under the same title, so the notice provisions of the Trust Act automatically apply, but in this case, we have to separately add them in because the titles are different. So the legislation adopts the methods of notice that are written out in the Maryland Trust Act, and there's really not much more to it than that. So with that, I, and on behalf of the Maryland State Bar Association, urge you to issue a favorable report for Senate Bill 158. That's all. Thank you.
And we'll be happy to take questions. Thank you.
Thank you.
All right, that'll conclude the hearing for Senate Bill 158. We'll now move on to Senate Bill 22.
22, this is the last bill of the day. Thank you, Mr. Chair. And I welcome Mr. Lasley. Some of the committee members who've been here some years will remember Jonathan Lasley, who has been very active in the Estates and Trust section of the State Bar Association for many years and has appeared before this committee on many occasions. So this bill wants to create a task force to study the fiduciary adjudication in Maryland. Maryland created the Orphans Courts back in 1777 to assist families with the transmission of wealth on a member's death. Since then, the methods for holding and transmitting wealth have changed significantly, and probate and fiduciary legal issues have become substantially more complex. Nevertheless, we recognize the value that a specialized court brings to families in times of transition. We also recognize the need for further changes to fiduciary adjudication in Maryland to provide a more uniform and efficient system for citizens today. We don't want a particular issue to be resolved one way in an orphans court in a rural county and another way in an orphans court in a suburban county and yet another way in the orphans court for Baltimore City. It would be best if we had some system of more uniform adjudication statewide. So in 2022, there was a task force to study the Maryland's orphans courts. I was on the task force. At the end of the year, it issued a report identifying certain inefficiencies and other problems with the selection of judges for and adjudication of matters before the orphans courts. As Jonathan Lasley will explain in a moment, more recent developments have further illustrated the problems illustrated in that report, including the lack of uniformity in probate adjudication across Maryland's jurisdictions. This bill would establish another task force to study fiduciary adjudication in Maryland, with a report to be due on or before next January 1st. The assignment given to the task force would be to examine the qualifications, training, and methods of selection of orphans court judges, to analyze the efficiency of the procedures for adjudicating contested and uncontested matters in the orphans courts and circuit courts, to compare Maryland's orphans courts laws and practices with the laws and practices of similar courts in other states, and finally, to make recommendations to improve the efficiency, uniformity, and quality of fiduciary adjudication in Maryland. This is a necessary preliminary step to the introduction of future legislation proposing a better system of adjudication in our state's orphans courts. So again, Jonathan Lasley is here, and I'm sure he would be happy to further indicate why this task force is necessary. Thank you.
Thank you, Mr. Chair, members of the committee. Thank you, Senator West, for sponsoring this bill. As Senator West indicated, where you are in Maryland depends on how your case before any type of fiduciary litigation goes forward. If you're adjudicating a probate case, you may be in a jurisdiction where you are in front of a panel of lay judges. You may be in a jurisdiction where you're in front of a single lawyer. You may be in a jurisdiction where you're in front of a circuit court judge who may or may, sitting as the orphans court, who may or may not have any experience with probate matters or other fiduciary matters. And some have less enthusiasm to sit on those cases than others. So it's a bit of a crapshoot as to what kind of court you're in, and that affects the procedures involved. For example, if you are in front of lay judges, you have a right to have the matter tried de novo at the circuit court level. So in essence, 2 bites at the apple. You lose at the orphans court, well, I messed up my case, fine, I'll just go try it de novo at the circuit court. In addition, since 1777, the estate and trust law has evolved substantially. Back then, the vast majority of property was probate, and it could be handled by neighbors, and that's why the orphans courts were set up the way they are. But now, most of people's wealth takes non-probate forms, but estate plans are integrated between probate and non-probate, such as non-probate examples are such as IRAs or revocable living trusts, those types of things. Jurisdiction over those assets resides right now in the circuit courts, where probate assets must start in the orphans courts. But those cases often are completely interrelated. So you have to try it at the orphans court level and then get it moved to the circuit court, consolidate the case. There are lots of perspectives here. There are lots of groups involved. There are good arguments for all sorts of different approaches, and that's why we think this task force is necessary. We've got amendments included with our testimony that I believe Senator West is amenable to, that we worked out with other groups to make sure that representation of various groups on the task force is equal and to protect the privacy of data that may be submitted by the courts and registers of wills. So with that, I urge a favorable report with the amendments as per our testimony. Thank you very much.
Thank you. I don't practice in this area, but you had mentioned assets that go into probate court and some that go into circuit court. Is that determined statutorily or?
Yes. So yes, and it's a blend of statute and common law. But probate assets are those owned in the decedent's own name that do not pass by reason of a beneficiary designation or a transfer on death designation or joint ownership or something like that, and that aren't held in trust. So if I own Blackacre in my own name, then when I pass, that is a probate asset, and that is subject to the jurisdiction of the orphans courts. Whereas if I take Blackacre and put it in a revocable trust, it's subject to the circuit court. And this is part of the.
And what if Blackacre is owned by you and your wife?
Then it would go.
Oh, it goes to the wife.
If I die first, it goes to my wife.
Right.
And then when she dies, it would be her in her probate estate.
Gotcha. Thank you.
Thank you.
All right, and I think Ms. McFarland you're going to testify with favorable with amendments? Yes. Welcome. Yeah, is Kelly here? Kelly Patori?
Sorry, she couldn't make it.
Okay, excellent.
Well, good afternoon, Mr. Chairman, members of the committee. My name is Byron McFarland. I'm the Register of Wills for Howard County. You saw my friend and colleague, the Register for Baltimore County here earlier, who is the president of our Registers Association. We are here today to support this legislation. I will just echo what Senator West and my friend and colleague, Mr. Lassley said. from our perspective as registers, we do see sometimes we have issues that arise in probate estates that are related to fiduciary matters that cannot be resolved by, as a matter of law, by us in our orphans courts. So we may have issues related to trusts, alleged abuses of a power of attorney. There may be issues related to questions of title that we do not have the legal authority to resolve. So to what Senator West said, there may be some kind of more efficient process for these kind of global fiduciary matters to be resolved. And I'm just here to say that that the registers, we are aware of the frustration that this can cause to folks we work with, particularly people who are pro se, who are frustrated that they've got to have a proceeding in the orphans court and in the circuit court. And as Mr. Lastly said, you know, some jurisdictions have attorney judges as orphans court judges. Some of us use a circuit court. So it varies by jurisdiction, and that can be frustrating as well. So we look forward to hopefully being part of a collaborative effort to take a deep dive into these issues and see what recommendations, hopefully by consensus, that we can make to propose to the legislature for your consideration. And with that, we ask for a favorable committee report and adoption of the amendments.
And let me just add that if the amendments referred to are the ones that I have been provided with, I'm amenable to adding the amendments to the bill.
Excellent. Thank you very much. Questions from the committee? All right, seeing none, that'll conclude the testimony and the hearing for Senate Bill 22 and our hearings for the day. We're going to take a 5-minute break so we can reboot, and then we're going to jump right into voting, and we'll hopefully get through. All right, 5-minute break.